second. My name is Martha Kome. I'm the chairperson of the Judicial Service Commission, and I welcome you for this interview.
Thank you.
Good afternoon, Judge.
Good afternoon.
My name is Isaac Ruto. I'm the Vice Chair.
Thank you, Commissioner.
Afternoon, Judge. Jacqueline Ngutia, Commissioner. Welcome.
Thank you, Commissioner.
Good afternoon, Judge. Zilani Caroline, Commissioner. Karibu sana.
Thank you, Commissioner.
Good afternoon, Judge. My name is Charity Gisotu. You're most welcome.
Thank you, Commissioner.
Good afternoon, Judge. Mwanza Ombati.
Thank you, Commissioner.
Good afternoon, Jokindo.
Thank you, Commissioner.
Yes, good afternoon, Judge.
Good afternoon.
Anthony Mrima. Karibu sana, Judge.
Thank you, Commissioner.
Good afternoon, Judge.
Good afternoon.
Fatuma Sichale, karibu sana.
Thank you, Commissioner.
Good afternoon, Judge. You're welcome. My name is Olwande Evelyn.
Thank you, Commissioner.
Good afternoon, Judge. Dorcas Odur, Senior Counsel and Attorney General.
Thank you, Commissioner.
Thank you, Commissioners, for that introduction. Judge, I will start by asking you to tell us your county and your ethnicity.
My lady, my county is Kakamega, and ethnicity is Isuha.
Very well. You can start off by telling us also why you applied for this job in the Court of Appeal. What are your core values and how they will come to bear in this position of a judge of appeal if you are successful? What are the special skills, abilities, competencies you're bringing to this court if you are successful?
Okay. Thank you, my lady. As you've heard, my names are Hedwig, Imbosa, Ong'udi. I'm a judge of the High Court and currently stationed in Nakuru as the presiding judge. I joined the judiciary on 22nd of July, 1985 as a district magistrate 2 professional. And that was soon after my studies at the Kenya School of Law, so which means I have been in the judiciary all along. And during my time in the judiciary, I've risen through the ranks. I was a magistrate up to the year 2011 when I was appointed judge. And during the time I was a magistrate, I served in a number of stations all over the country, save for the Coast Province, the Coast County. I also headed 5 stations as a magistrate, and that is Eldoret, Kitale, Kisumu, Kakamega, and Kericho. When I was appointed judge, I was the chief magistrate in Kericho. That is in August 2011. As a judge, I've served also in various stations, starting with Embu, Kericho, Nairobi, Makueni, and now in Nakuru. When I was in Nairobi, I served in the Anti-Corruption and Economic Crimes Division, shortly at the Civil Division, and then in the Constitutional and Human Rights Division. before I was transferred to Nakuru. So during my the period I have been in the judiciary, and before I forget, last year in July, I was celebrating my 40th year in the judiciary. And I don't take that for granted, and I thank God for that, because it's Him who has sustained me. I've served in the judiciary with a lot of commitment, integrity, and service to Wanjiku and even our own staff. I've had the experience of working in several stations. You know, the way one handles matters in Nairobi is not the way you would handle matters in Nakuru or even a station like Kitale. The challenges are quite different. So I've had that experience, and for the anti-corruption division, I was the first presiding judge when that division was set up. I worked with Justice Achode, who was giving support because she was also attached to another division. During my term also, I got an award. I was awarded by LSK in 2019 for being the Judge of the Year, which I appreciated. And when we had the vetting in 2011, 2012, I was among the judges and judicial officers who are recognized by this vetting board as being an officer who was committed to their work with good temperament and good service to Wanjiku. During the time I have presided over various stations, I've learned a lot on how to work with colleagues, how to work with staff generally, because if these staff are not appreciated and acknowledged, and yet they are the ones who do quite an amount of work for us, we would find ourselves in a lot of trouble. So those are some of the skills that I have acquired. So besides being a judge, I'm also a mother, a grandmother, and a leader in the church. Thank you.
That tells us the kind of a person you are.
Thank you.
So how would you help to reduce the backlog of cases in the Court of Appeal?
Now, in the Court of Appeal, from what I've heard, is that we have quite a number of pending applications and then the appeals. With my commitment to good service, I would liaise or link up with my colleagues at the Court of Appeal, if I make it, and we see how we could have these applications disposed of within the shortest time and concentrate on the appeals. Because if we have a huge number of applications, then it becomes very difficult now to move to the appeals themselves.
That is one strategy. Another one? Anyway, you can think about it along the way. The next set of questions will be asked by Commissioner Mwanza.
Thank you, Chief Justice. Good afternoon again, Judge.
Good afternoon, Commissioner.
Judge, I want to ask you a question based on Article 19 of the Constitution. Article 19(3) provides that the rights and fundamental freedoms in the Bill of Rights A belong to each individual and are not granted by the state. Judge, what is your understanding about that?
So it means these rights are inborn.
Yes.
We don't get them from the state.
Yes.
Yes.
We get them because we are human beings.
Because we are human beings.
Okay.
Yes.
Now, Article 19(3)(b) provides that's so that there is continuity in terms of law. So 19(3) provides that the rights and fundamental freedoms in the Bill of Rights A belong to each individual and are not granted by the state.
Yes.
And you responded to that. And B, do not exclude other rights and fundamental freedoms not in the Bill of Rights, but recognized or conferred by law except to the extent that they are not inconsistent with this chapter. Judge, which are these other rights and fundamental freedoms that are not in this Bill of Rights?
And they are not in this?
Yes, actually the Constitution says, do not exclude other rights and fundamental freedoms not in the Bill of Rights, meaning they are not part of Chapter 4. But are recognized or conferred by law, except to the extent that they are inconsistent with this chapter. So which are these rights?
Commissioner, I can't think of any other right that is not in the Constitution here.
Oh, okay.
Yes.
Perhaps, actually, I found that curious. I think those are the rights that sometimes either they are created by law, conferred by law, or come through international conventions under 2(4). Any law, including customary law, that is not inconsistent with this Constitution. So if you read that. Now, I want to ask a follow-up question. So in one of the international conventions, that's the Universal Declaration of Human Rights, Article 16. So this will be one of the rights that you probably read together in terms of 19(3)(b). Provides that men and women of full age, without any limitation due to race, nationality, or religion, have the right to marry and to found a family. They are entitled to equal rights as to marriage, during marriage, and at its dissolution.
Yes.
You read that? Okay. Now, if you read Article just give me a minute. I had it here. The one on the right to family. Article 45. Article 45, Judge, says that the family is the natural and fundamental unit of society and the necessary basis of social order, and shall enjoy the recognition and protection of the state. 45(2) provides that every adult has the right to marry a person of the opposite sex, based on free consent of both parties. But Judge, if you read Article 16 of the Universal Declaration of Human Rights, the language is slightly different. If you noted, it says men and women of full age without any limitation due to race, nationality and religion have a right to marry and to found a family. They are entitled to equal rights as to marriage, during marriage and at its dissolution. Now, if a question comes before you and there are couples of the same sex, they say they want to rely on Article 16 to declare and ask for a declaration that it's permissible for a man to, enter into a partnership with a man, or a woman to enter into a partnership with a woman. Based on Article 19.3, would you declare that as a right that's availed by the law?
Okay, when we look at Article 45,
Yes.
2,
Yes.
which defines, which tells us more about marriage,
Yes.
and this one is our constitution.
Yes.
Now, Article 16,
19, sorry. 19. 16.
16, the
Oh.
universal one.
Oh, yes. Article 16 of the Universal Declaration of Human Rights
Yes,
reads differently. It says men and women of full age,
yes,
without any limitation due to race, nationality or religion, have the right to marry and to found a family. And they are entitled to equal rights as to marriage, during marriage and at its dissolution. There is no limitation in that article
yes,
with respect to the person that ought to be married. Is it the opposite sex or the same sex?
yes.
So a party has come and they are asserting their right. They're saying they've come to you under 19.3 B, and you should therefore declare a union between a man and a man, or a woman and a woman, as permissible.
Okay, Article 19,
Yes.
3B
Yes.
indicates that the fundamental rights and freedoms belong to each individual and are not granted by the state. But
Yes.
our Article 45
Yes.
talks about family and marriage
Yes.
of two people of different gender, right?
Yes. Yes.
Now, when this one comes and brings up that suggestion
Yes.
that they have a right to choose,
Yes, to choose who to love and who to partner with. Yes.
I find that to be contrary to what we have in our constitution,
Yes.
and our constitution comes first.
Okay.
Yes, so I would not allow it.
Okay. All right. Thank you. That's all, Judge.
Thank you, Commissioner.
Honorable CJ and Judge Karibu. Once again, two questions from me. One on the access to justice. This is Article 48, the right to access to justice. And having been in the institution for quite a good time, what has judiciary done to enhance this right in Kenya?
Access to justice.
Yes, please.
Okay, the Judiciary Commissioner has done quite a bit. It may not be complete, but the judiciary has tried. One is enhancing the number of judges, judicial officers, and even judicial staff
Yes.
so that they can serve Wanjiku. And then we've opened quite a number of courts where we did not have any, so that Wanjiku can easily come to court without much struggle or spending so much money in terms of fare. And we have set up in the judiciary bar benches where bar benches where we have consultation or we discuss issues that are affecting mwananchi and even us in the delivery of justice. We also, like in Nakuru, what we do, every morning we have a team of staff, about 4 or 3, talking to members of the public who come to the court for services. So they are told what they need to do, what they should not do, if they have issues, which office they should go to, and so on. And those are things that were not there.
Okay.
Yes.
Including our Honorable CJ's vision,
Yes.
the starch, isn't it? The
Yes.
blueprints.
Yes.
Okay.
Thank you.
Now, what do you think the legislature can do to enhance that right to access to justice? Parliament, what can Parliament do to enhance that right?
Okay, the challenge that has been there is about funding,
Yes.
so that despite the fact that we have structures in place, the funding that we get from government is minimal.
So what can Parliament do? Can enhance our funding, isn't it?
Yes.
Thank you. Thank you. And lastly, on citizenship, are there instances where citizenship can be presumed in Kenya? You can presume someone to be a Kenyan.
When they were born in Kenya,
No, a presumption of citizenship. When you talk about presumption of citizenship, then you are not sure whether they were born in Kenya, but I'm asking whether the law or the constitution allows instances where one can be presumed as a Kenyan.
Commissioner, that one.
You must have dealt with it when you dealt with the famous case. Do you remember the famous case you really dealt with? The hot one.
Which one?
We were together at the CHR.
You know,
Yes, presumption of citizenship arises where a child under 8 years, whose nationalities are known and whose parents are also unknown, is found in Kenya. The law allows that person to be presumed as a Kenyan. So thank you so much, Judge, and I wish you well.
thank you, Commissioner.
Good afternoon, Judge.
Good afternoon, Commissioner.
What is your general understanding of extradition?
Extradition occurs when another state requests, say for example, another state requests Kenya to have someone who is in Kenya taken to that country for one reason or another, and especially in terms of criminal matters.
Give me 2 reasons in criminal matters where extradition would apply. You're right that it's another country requesting.
Yes,
Extradition, it's a very important framework in international law,
yes,
and it is supposed to help countries deal with criminals who disrespect borders to escape justice, isn't it?
yes,
And it's so important so that we can fight transnational crime. which is now very fast, can be committed using technology even in the cyber world, and for us to keep within the rule of law. Now, in Kenya, what is the legal framework that can be invoked to facilitate extradition?
In Kenya, we have 2 statutes. Extradition, and then in brackets, I think Commonwealth, and there is extradition for foreign. The other name I forget.
We have the, yes, you are right, Extradition Commonwealth Countries Act,
Yes.
that binds Commonwealth countries,
Yes,
and Extradition Contiguous and Foreign Countries Act, which
Yes.
are non-Commonwealth countries.
yes.
Other than those 2 legislations, which other frameworks can be applicable for extradition as a basis for extradition?
Okay, if it involves a country that has some arrangement with Kenya, the 2 countries would do that.
You are on the right track. It's only that maybe it's the terminology, where we have bilateral agreements and multilateral agreements that can also be a basis for extradition. Now, the Supreme Court recently settled the law on extradition proceedings in Kenya. Are you aware of this case? And if you are, which case is it? And what was the legal question presented before the Supreme Court for determination?
The case, is it Okemo? But I'm aware there's a decision, and the main issue before the Supreme Court was whether it is the DPP or the Attorney General who should handle such an issue when it comes over.
And what was the decision of the Supreme Court, or the guidance?
Okay. The decision was that following the 2010 Constitution, the DPP's docket under Article 157 is to deal and handle criminal matters, and not as before when the Attorney General was involved. So it is the DPP who should handle that, since it's a criminal case. But the Attorney General is, the request comes through the Attorney General, who now notifies the DPP.
Taking into account that the DPP under Article 157 deals with criminal matters and the Attorney General under 156 deals with civil matters, did the Supreme Court categorize extradition?
No, extradition is mainly concerned with crimes that have been committed in the country that is making that request.
So did the Supreme Court attempt to categorize extradition, whether they are criminal proceedings or civil proceedings?
The Supreme Court indicated that extradition is about criminal matters.
Finally, Judge,
yes,
would you give us 3 grounds or 3 tests that are applied as a basis for extradition or for refusing to extradite?
The first one, is it dualism?
I'm listening.
It's dualism, where the country that is making that request, and Kenya, I'm assuming that the request is made to Kenya, and Kenya are in agreement on that, operation. And then the other one
Which operation?
on extraditing.
Do you mean dual criminality?
Sorry?
Do you mean dual criminality? Or which dualism?
Okay. My understanding is that these two countries, Kenya and the other country that is making the request, have some sort of...
Agreed.
Yes.
Another one?
And then another one, some speciality whereby the person that is the request is made for may be having some challenges, maybe health-wise, and the age also, so that he falls or she falls in that special category, then it may not be allowed.
A third one?
The third one, I forget the name, but it's whether the country that is requesting for this person would want to exercise a death sentence on them. So that, you know, if he's released by Kenya, he's taken there and he's...
I appreciate. You don't have to remember the name, but you know the fact, you know the text, because I'm sure you know where to get it. Thank you so much.
Thank you, Commissioner.
Thank you very much, Honorable Chief Justice. Judge, you have indicated that one of the great strides that we've made as a judiciary is that we are now using technology in almost every facet of the judiciary, be it filing cases, making returns, and of course, even hearing matters. Now, in respect of trial courts, please tell us the pros and the cons of handling matters virtually. Maybe we can begin with the pros.
Okay, for the pros, I would say matters move faster, speed.
What contributes to the matters moving faster? What's the advantage? What are the advantages that we obtain by going virtual?
You may hear a matter from wherever you are.
Okay.
Yes, because initially, if you are not at the court premises, you would not hear the matter, since it had to be done in open court.
So that's one advantage. Another
yes.
one?
Witnesses that are not able to come to court will give evidence from wherever they are, as long as they are able to access a facility.
All right. Almost like the first one.
I think basically
those, you can just think of those two.
Yes.
What are the cons?
One main one is about the witnesses that are presented.
Yes.
It has been whispered that sometimes whoever is giving evidence is not the witness that is supposed to be. So
there is that possibility of witness coaching?
Yes.
In fact, we hear that a witness is sitting on her table or on a chair, and somebody is holding
a paper or something for them to see.
And he or she is reading it.
Yes.
So in terms of the administration of justice, How is this affecting the administration of justice?
Now, it affects the administration of justice because what you are getting is not, would I call it proper evidence, or it's not the truth.
Okay.
Yes.
So that is one, witness coaching. Any other?
We have also seen some instances where the parties or the advocates appearing are not formally. You know, people just come to court, not
So
formally dressed. You know, in
diminished formality.
Yes.
Diminished formality.
Yes.
Isn't it?
Yes.
Okay.
And even sometimes when they are addressing the court, things that they may not say in open court when they are there, they would, when it's virtual, they'll just tell you anything.
Okay.
Which is disrespectful.
So lack of decorum.
Yes.
That has also diminished.
Yes.
Anything else? There was a video clip that was doing its round some time back where an advocate appeared while she was still in bed. Did you see that one?
I just heard about it. I didn't see it.
Okay.
But that is all about decorum. They don't take the matters seriously.
All right.
But for the judicial officers, I don't think there's any of us who does that.
All right.
Yes. At least I've not heard of any.
No, I didn't even ask about judges and and magistrates. I asked about advocates.
Okay.
Now, you've of course worked in the judiciary for a very long period, 40 years.
Yes.
And in terms of credibility of the witness, what would you say?
Credibility?
Is it important, particularly in terms of a criminal trial?
Now, of the witness testifying virtually,
Yes.
or?
Yes, we are talking about the cons.
Okay.
Yes.
Credibility. Okay, from my experience, the witnesses who normally testify, except for a few, who normally testify virtually, you know, you really don't have that confidence that they are serious. And
Are you able to observe their demeanor?
you are not able to observe their demeanor.
Okay.
Yes.
And finally, from me, under the Civil Procedure Act and under the Civil Procedure Rules, the Act and the rules provide for a place of suing, correct?
Yes.
So that if, for instance, a plaintiff is filing suit in respect of a land matter, where should that suit be filed?
The suit should be filed where the land is actually grounded.
Okay.
Yes.
And where it is not land, somebody is filing suit to recover money from a defendant, where should the suit be filed?
Okay. Maybe from where the money was borrowed from.
Where the cause of action arose?
Yes.
Yes.
Where the cause of action arose, or could be.
No, it's not could be. 40 years is not a short period. And I will not take that answer. So where the cause of action arose, or?
Where they reside.
Who?
The defendant.
The defendant, correct.
Yes.
Now that we have all these technological advancements, where distance no longer matters, we can hear cases virtually. Is it time that we amended the Civil Procedure Rules and the Civil Procedure Act in terms of it providing for place of suing? What is your view?
I think we may need to amend some of the rules so that that is accommodated. Because if we do not do that, a person will come to court and make an application that the suit be struck out because, it's not been filed where it ought to have been filed.
But it doesn't matter anymore.
Yes?
The reason why it was being filed, the consideration is where the defendant is not to inconvenience him so much.
Yes.
But now where is the inconvenience? He'll join online and the matter will be heard.
So then...
This we are speaking nearly from the same page. Thank you.
Thank you, Commissioner.
Yes. Before I come to my substantive question, I had a question as I was going through your documents. I see that you used to use the initial P in your documents, but it got dropped.
Yes.
So what was P for and why did it get dropped?
Thank you, Commissioner. Now, if you've seen that document, where the P was, it was Mulama. Yes. Hedwig P. Mulama. Now the P, those days you'd put your dad's name, so it's Petro Mulama. Now, when I got married, I left out the P Mulama and took Ong'udi.
Okay.
Yes.
So you've started using double barrel before a lot of people. That's really good. Okay, to my substantive question now. In which way can we make an amendment to the Constitution? How do we amend the Constitution?
The Constitution can be amended through, now how do I put it? There are steps which need to be followed before any part of the Constitution is amended, because the Constitution is Kenyans speaking.
That's true.
Yes, so there
what are the steps?
Yes, there has to be civic education, civic education, then public participation,
yes.
And the matter is also discussed in Parliament and the county assemblies. Then there is referendum.
So that is amendment through popular initiative.
Yes.
Is there another way in which the Constitution can be amended that is not popular initiative?
Okay, Parliament can initiate if the amendments are actually minor amendments. Parliament can.
Constitution, the public initiative way,
yes,
and the parliamentary route.
Yes.
So, assuming hypothetically, we have a proposal to divide Nairobi County into 2 counties. What route do you need? Which one can you take? The parliamentary route or the popular initiative route to make such an amendment for Nairobi to be divided into 2?
I would go for the popular initiative because Nairobi hosts a big number of Kenyans, whether they are from different counties or not, and they even undertake businesses. So it would be good to have a public initiative.
Okay, thank you so much.
Thank you, Commissioner.
Thank you, Honorable Chair. Good afternoon once again, Judge.
Good afternoon, Commissioner.
Please have some water. Are you okay?
I'm okay.
Thank you. Glad to hear that. I've gone through your sample writings, Judge, and they reflect correct application of statutory provisions, precedent, and established doctrine. You demonstrate consistency when it comes to
the issue of applying the law, the facts, and you maintain coherence when it comes to linking analysis and conclusions.
Thank
You predominantly seem to be a textualist, and when it comes to interpretation of the Constitution, and you also are sensitive to the context of the circumstances of each case that is before you. Your reasoning is well measured, well structured, and reflect judicial restraint and fidelity to the law. There is a conference paper that you did submit. They show how you're able to think through complex legal concepts, particularly in economic crimes, reinforcing the grasp of legal standards and burden of proof.
Thank you,
So
Commissioner.
congratulations for the good job that you do in drafting the judgments and rulings.
Thank you, Commissioner.
Judge, you mentioned you joined the judiciary in the 80s. What year precisely? 80?
1985.
1985. I don't want to say where. Several transformations that have been done within the judiciary, different chief justices coming in, different judges, magistrates, and staff. And in the past, the past two, and the current blueprints are all aimed at transforming the judiciary. There is a saying by U.S. political scientist James Wilson that reads, "Institutions do not reform themselves. People within them must choose to act differently." This then speaks to the culture within the judiciary. So what, from your experience, what aspects of judicial culture most undermine reform within the judiciary? Because yes, Kenyans are aware there is transformation, but they feel there has to be something different that must be done. So where you sit, you've been around for many years, what do you think are some of the things that undermine the change of culture?
Maybe one of the things that have hindered us from changing culture is fear. Such that, as a judge, as judicial officer, you don't feel that free to speak your mind and apply the law the way it is, maybe because of fear of repercussions.
Is it external or internal pressure, or both?
Both.
So one is fear, the other one?
Before it was a lack of training, but in the last few years, that has gone on quite well.
Okay, so then what needs to be done
Yes.
to address the issue of fear, so that people are able to do what is right without any form of repercussion?
I think it has to, when we look at the example of Her Ladyship, the Chief Justice, she's open. And so she's open, she'll speak her mind and tell us what we need to do. So it is us now in the courts, in the lower courts, those of us who are maybe presiding judges or heads of station, we should have that interaction with our staff and explain to them exactly what needs to be done and we should also be setting examples for them, because you cannot be talking about this and yet asking them to do this, and yet you yourself, as a leader, you are not complying with that.
Lastly, on judicial performance, I'll focus my question with regards to performance of judges. So there's usually the annual target that is given, where judges are expected to deliver at least 110 rulings and judgments. And if you look at the performance report, there are those who are way, way below the performance, and yet they are in stations or in divisions where I would, for lack of a better word, use not too complex matters. How best can this issue be addressed so that judges carry their weight, judges are accountable for the time and resources that Kenyans have given to them to do what is required?
Thank you, Commissioner. One thing I usually ask myself, when you applied, when one applied to join the judiciary, whether a judicial officer or a judge, nobody forced you, unless. So when you are coming, in fact, that's part of what the JSC asks. What are your expectations? And when you are coming, you know very well what is expected of you. So you have to hear cases and make decisions, because if you just hear a case and you keep the file there without making a decision, we are not assisting Wanjiku. And that is not something that someone should be following you so that you do that work. That is what brought us here.
So there are those who are not doing it. So what should happen? Ordinarily, what system should be put in place to they adhere to regular communication from the Chief Justice? For example, uploading of decisions. We hear some of your colleagues are uploading blank papers to beat the system.
Okay. I would suggest that at the end of every financial year, what we have done is publicized. Then, if one has not performed as per the expectations, they would be asked by the employer, who is the JSC.
Okay. Thank you. Thank you, Judge, and I wish you the very best.
Thank you, Commissioner.
Thank you, Honorable Chair. Judge, I like what you said about you cannot be a leader and do the opposite of what you are preaching. Preach water and drink wine. And I think that is also borne by the report we have on you from DISPOP. I think you are one of those leaders that lead from the front. And I commend you for that.
Thank you.
I'm assuming you have seen a copy of your report from DISPOP.
Yes.
Okay. So the report is quite good. It shows here that out of the expected resolution, there's 4 of you at Nakuru?
Yes, Commissioner.
Yes. Out of the expected resolution of 25%, you are carrying 44%, almost half the resolutions in your court station. I think that's commendable. And I understand you're also the PJ.
Yes.
Yes, and considering you also have the extra responsibility of the administration of your division, I think this is very commendable. Now, riding from that, earlier when you were engaging with the Honorable Chief Justice, she had asked you about the strategies for clearance of backlog. I would say they are similar to also what you do in terms of increasing case clearance rate or expediting disposal of cases.
Yes.
So I want to imagine now you are settled, you probably, because you only mentioned one, you probably can mention the others, that you also employ in your court to be able to post such good results.
Okay. One, I usually have discussions with my colleagues.
Mm-hmm.
And if there's any report or anything that I find not going our side, I have a meeting with them, and we have a good team. So I let them know that this is what is there and we are not doing well. Why is it that they know that I am aware? Because if you just keep quiet, people will just do things the way they would. Yes? And same even for the magistrates also, though I'm not their immediate supervisor,
Yes.
but I show that I am interested to know what it is that they are doing in the station.
Okay.
And then, of course, we have meetings, staff meetings, and they have to be told exactly that. Yes.
Okay, one of the other strategies that we employ as an institution, there are several. There is the service weeks, which I believe you carry out at your station. Service weeks?
Since I went to Nakuru, we've not had any
Service
week there.
But you are aware, even as an institution, we normally
Yes.
carry those out in order to expedite conclusion of cases, especially
Yes.
the old cases.
Yes.
Yes, and it's good that you also work very closely with the magistrates. So you've also heard about Mahakama Popote.
Yes.
So maybe you could tell us what is the difference between those two strategies and which is the most efficient in your view?
Now, Mahakama Popote, from what I've learned, is that they do the matters virtually, and they can handle matters from other stations. But Nakuru is such a heavy loaded station.
Yes.
And from the work even the judicial officers do, I would not expect them to be so active in the Mahakama because it may affect their work in the station.
Actually, the way they would be participating is that they would be beneficiaries of Mahakama Popote because, as you say, Nakuru is a heavy station. So they may not be participating in terms of handling work from other stations, but their work is possibly being handled by other stations, isn't it?
Yes.
Okay. So now, what's the difference between that and what we call service weeks? What happens in service weeks? You've already told us what happens in Mahakama Popote. You have courts, magistrates from other stations handling work from other stations virtually.
Okay.
Service weeks?
The service weeks mainly deal with, let me talk about the High Court.
Yes.
The service weeks mainly deal with appeals. Appeals whose records are ready, and the files are too many for the judges who are there. So they are put together, then we make a request to our principal judge and even give the figures.
Yes.
Then, once authorization is given, we make those arrangements and they come.
Okay.
Yes.
So you have visiting judges to help with the workload.
That is, we have not invited any.
I know
Yeah,
for Nakuru
but
you already told us, but that's how it works.
Yes, that's
how
it
it
works.
works. So it's good you're even addressing the other part of my question on how you prepare for it.
Yes.
So you've indicated that you prepare, then you make a request to the principal judge, and once he authorizes, then other judges will visit the particular station
Yes.
and assist with appeals, you said.
Yes,
So what is the basis or what are the considerations for getting that approval?
Okay. You give the statistics and you also indicate to the principal judge how many files are ready. Because there would be no need of getting that permission and another judge just comes to the station.
Yes.
To do basically nothing.
Or to just mention
In fact,
matters.
that's what used to be done a few years ago.
Yes.
Yes.
Okay. I'm glad you have brought that out because I know we have really improved in how we carry out the service weeks, just as you have said, even
Yes.
how we prepare for them. Now, lastly, the other part of my question, which you've not answered yet,
Which one?
which is the most efficient out of those two in terms of the productivity and resources? The most efficient between the two. mahakama popote and service. I know they're applied in different courts, but in your view and in your understanding, which would be the most efficient in case disposal?
When I consider Nakuru, I think the mahakama would be the best option because they will handle all matters and see how fast they can dispose of them. Yes.
And the beauty of it, there's no cost.
There's no cost.
Yes.
Yes.
Okay, thank you very much, Judge, and I wish you well. I also commend you for the good work.
Thank you, Commissioner.
Thank you, Honorable Chair, and welcome again, Judge.
Thank you, Commissioner.
Yeah, I hope you are not tired.
No.
You can take some water.
Okay.
Okay. Now, I want to read a statement here. Judge, you will tell us what you understand by this statement and the views, and your views on this statement.
Yes.
A judge should measure twice and cut once. That is, take time, weigh the choices carefully, and let integrity and public good guide the path to justice. Can I repeat?
Yes, please.
Okay. It's a statement from one of the stakeholders. A judge should measure twice and cut once. That is, take time, weigh the choices carefully, and let integrity and public good guide the path to justice. Yeah. What do you understand by that statement, and what is your views?
My understanding, I'm just trying. My understanding is that, okay, being a judge, a matter is placed before you, and you hear it from both sides, and you have to be, you have to analyze it and make a decision. And you don't make that decision because of any other factors, but because of, you look at the law and the material that is before you. So you work in integrity.
Thank you. Now, how do you identify and prioritize stakeholders with competing interests?
When they appear before me, you see, now the issue of competing interests is between the two of them. So I will let them tell the court what has actually brought them, and then I consider their material plus their submissions and what the law says. Yes.
Thank you. Thank
Then
you.
they can go and fight outside there.
Right. You will let them go and fight?
No, not let them. You see, Commissioner, some of the decisions that we make, especially in succession matters, you make a decision, you feel you have done your best, but when these people leave the courtroom outside there, you never know.
Right. Okay. Thank you, Judge. Your report here from the stakeholders and the public that gave views on you have no issue with you. They say you don't have any integrity issues.
Thank you.
And they applaud you for a good job. Thank you very much.
Thank you,
and all the
Commissioner.
best.
Thank you, Commissioner.
Thank you, Honorable Chief Justice. Good afternoon, Judge.
Good afternoon, Commissioner.
I have 2 or 3 questions for you. Now, you joined the institution in 1995.
1985,
yes, before Gen Zs came to existence. and even some millennials. I know because I'm a millennial, I'm not a Gen Z. I just want to ask you, what has been your interaction with this very unique group of individuals in the institution, bearing in mind that they are quite a number?
Thank you. Now, these young people, you know, without interacting with them, because they have issues that unless they are addressed or they are actually talked to, they feel they are discriminated against, or the institution does not value them. So I have made them my friends. I talk to them, I give them whatever assignments are there, I give to them so that they feel that they belong. Because the moment you sideline them, it becomes difficult. Some of them will not even come to work, and for no good reason at all. Yes.
Okay. Are there any lessons you learn from them?
Yes. One, without that guidance, they will always want things done their way. But when you talk to them and tell them this is not your father's business or whatever, we have to comply with the guidelines, we have to comply with the rules and so on. And I find working with them quite comfortable, and they like me.
Okay.
Because I listen to them, and they will come to my office if they have an issue. They will come to my office and
promote diversity in the judiciary.
Diversity in what sense?
In our employment processes. What are some of the ways that not just judiciary, even other organizations can adopt to promote diversity?
I can't think of any immediately, but I think the judiciary, so far, the judiciary is doing well. When there are vacancies in the judiciary, it's advertised, people apply, and then we have the interviews. And I know that even when the candidates are being picked on, there's the element of regional whatever, so that there's a balance.
Affirmative action?
Yes.
Is one of them?
Yes.
Okay. You will need to look at other ways that you can promote the same. Finally, Judge, we are told that you're one of the judges that sit in court on Fridays while majority are retreating to do their writings.
Yes.
When do you retreat to do your writings? How do you go about it?
Now, Commissioner, when I'm at the office on Friday, I do my writings. Unless there's an urgent matter which has run over from the previous day, and I know it's not a long matter, so that we start. Sometimes I even tell them they've been caught at 8, so that by 10, 11, we are through. Then I now start working on my judgments and rulings.
So you're able to ensure that there is proper work-life balance,
Yes.
and that you're not burning out?
No.
Okay.
I've not had that, and this is something that I'm so used to.
Okay.
For these many years that have been there.
Okay.
So that nobody, I don't need someone to come and panel beat me. Ong'udi, you need to work on this. No.
Okay.
Yes.
That's a very positive feedback that we get. Keep up the good work, and I wish you well.
Thank you, Commissioner.
Thank you.
Good afternoon, Judge.
Good afternoon, Commissioner.
Hope hujachoka sana
Hapana, sijachoka, Commissioner.
kukaa kungojea sisi, waiting for us to see you and then sitting here for 2 hours. But I believe we will not take any longer. Now, community service,
I do a lot of it.
a lot of it.
Yes.
Where?
I do it in Kitale,
Mm-hmm.
which is my home. I do it in Kakamega, where I was born.
Mm-hmm.
I even do it in Nakuru. The stations where I work, I always organize for that.
What motivates you to personally to engage in community service?
One is my faith. Number two, even as I serve these people in court, you know, there's instances where you hear them talk and you feel within yourself, this is somebody that needs help. Yes.
Okay, how does community service contribute to social justice and equity?
Community service contributes to social justice because when we give support to members of a community, or, you know, they feel they belong. They feel, you know, they are not the odd man out. And they are part of family, and there are people who see their need. Yes.
Thank you very much, Judge. Wish you well.
Thank you, Commissioner.
Thank you very much. Commissioners, I think we have really engaged the judge, but I still want to know what would be your response. First of all, acknowledging and thanking you for a committed service of 40 years. You are now on your
Yes,
41st.
my lady. Yes.
And this is why I'm asking you this question, which comes from a maxim that energy has limits. So do you. Having served for 40 years, might you be drained? Might you be tired as you go to the Court of Appeal?
Okay. Thank you, my lady. I wouldn't say that, and to serve as much as I can, because if I say now, I just sit there and say 40 years or 60 something years, I will not work. I don't think I will have peace within myself. No.
Very well. Because it's good to generate inner energy within yourself, which keeps you going. To begin this interview, you said Nakuru is calm. And I know we were aware that there were skirmishes where the advocates were threatening to boycott the court.
Yes.
And I'm happy you took some interventions that forestalled that kind of action. What lessons did you learn, especially when it comes to addressing the root causes that may cause advocates to say they are down in their tools?
Thank you, my lady. Some of the things I learned, and I was even asking my colleagues. You see, we have been called in this profession. Now, when we hear matters and you don't deliver judgments, because that was one of the main issues, when you don't deliver judgments.
JOs and judges were not delivering judgments.
That was the complaint.
Yeah.
Yes. So, and I was asking them, some of them, especially the JOs, they had files that had been kept for 2 years without. So I was asking them, during this 2 years period, do you want to tell me you've not had matters, you've not delivered judgments in those particular matters? So what excuse would you give for not delivering this? Because those are some of the reasons which make Mwananchi to start making allegations. My matter is not being, judgment is not being delivered because of ABCD. You see? So I talked to them that, and I was just learning that having that a cordial relationship, even with the advocates, you know, you'd get to know exactly what their complaints are, and even the judicial officers and judges, what their shortfall is, what it is that is challenging them, and things like that. So that communication is important.
Communication.
Yes.
Did you develop like a template that can help you as the presiding judge of the station know who has judgments or rulings that are pending, so that they don't wait for 2 years until advocates threaten to down their tools?
We are working on that one, my lady.
Yes.
Yes.
A template that
Yes.
everybody, every month, you can be able to know. And now, because we are using technology,
Yes.
that should be very easy.
Yes.
Thank you, Judge. I think this brings us to the end of a very engaging interaction with you.
Thank you, my lady.
We wish you well and commend you for the good work that you have done over 40 years and continue to do for the people of Kenya. But before we release you, we always give a candidate an opportunity also to engage with us. The floor is yours now.
Okay. Thank you, my lady, and all the commissioners. Mine is just to say thank you for having the opportunity of appearing before you. I do not take it for granted. And I also want to thank you for the patience. I know you are tired, but you've kept moving on. So my prayer is that even as we finish with the interviews, the Lord may guide you on what you need to do. Otherwise, I'm grateful, and I say thank you.
Thank you very much. May
Yes.
the same rod continue
Yes.
guiding you and
Yes.
shining its light upon you every day.
Thank you, my lady.
We will now release you,
Okay.
and somebody will escort you to where you can have some lunch.